Good morning, everyone. We're just about to start the webinar, and we'll just wait a few more minutes because there are a lot of people just registering now and coming in to this webinar. So we'll just wait a couple of minutes. We see quite a few coming in. Just before we start, just a reminder, if you want to ask a question, you can ask a question over on the right-hand panel under the chat section, and you can pop a question in there. Or if you want to also ask a question, a broader question, under the question area, which is directly under the video. If you just scroll down, you can see an area for questions. So we're happy for you to put your question in there, and then Kirsten will answer it. So we'll just give it another minute or half a minute, and then we'll start, and we'll introduce Kirsten in a few moments. Right, okay, so welcome to the Brainstorm Room, and a big welcome and thank you to Kirsten Maclean for being our guest today. I'm Jamie Tulloch, MD of E3 Business Accountants and co-founder of the Brainstorm Room. Before we hand over to Kirsten, I'd like to tell you about the Brainstorm Room. The Brainstorm Room was born during COVID-19 Level 4 lockdown. During a Zoom brainstorming session about how best to support our business owning clients who needed all the help and support and guidance they could get to survive and then thrive, the team here at E3 had a startling thought. Can we gather together a team of voluntary experts who will offer Kiwi business owners free access to their knowledge, skills, experience, and to help them survive and thrive? So we contacted a number of professionals, business advisors, and successful entrepreneurs to ask if they would support such an initiative. Look, the feedback was overwhelmingly positive, and so the Brainstorm Room was born. And the mission of the Brainstorm Room is to give every Kiwi business owner a fighting chance to survive and then thrive. And we believe that every business should be enjoyable, profitable, and sustainable. Now, I'll tell you a little bit about the webinar, and then we'll introduce Kirsten. Kirsten is a lawyer with 20 years experience, and she specialises in dispute resolution, HR, and employment issues. Now, Kirsten is a litigator with over 20 years of experience and in all forms of dispute resolution, both here and in England. Kirsten is also qualified, I lost my place there. Kirsten is also qualified and admitted to the UK solicitor's role. Sorry about that, Kirsten. Now, prior to setting up Sidekick Legal, Kirsten was a partner of a medium-sized Canterbury law firm leading the litigation and employment team. Kirsten will start with about a 15-minute overview of the critical elements that employers must know about if they are thinking or planning a restructure. A restructure usually involves employees and the legal responsibilities to look after everyone in your business run deep and wide. There are many traps that even the most well-intentioned employer can fall foul of. So good intentions are seldom a defence if you get things wrong. Kirsten will tell you about that soon. Kirsten is here today to talk through the trips and traps that can snare anyone who doesn't carefully plan every move. Kirsten will also go through some of the new employment laws that are coming soon. During this webinar, we will be accepting questions that Kirsten will answer. So just type your question into the chat area on the right-hand side of your screen, probably that way around if I change hands, or in the question area directly below the video image. What Kirsten doesn't get to answer today, she will personally respond to you by email within the next few days. You can choose you'll have your question answered live today, or if it's confidential, Kirsten can answer it privately later. So just tell us your preference on how best to answer your question. So to get the best out of this webinar, take notes if you can. And for all those who asked, yes, this webinar is being recorded, and you will be sent an email within 24 hours with a link to watch a replay at your leisure. So Kirsten, welcome to the Brainstorm Room, and thank you for taking valuable time to reach out to our audience today and share what is to many employers a very difficult area of business. Over to you, Kirsten. Thank you.
Thanks, Jamie. And look, firstly, I just want to acknowledge the Brainstorm Room. I think it's a phenomenal initiative, and it's certainly the year that people have needed support. So it's a real honour to be part of it. So thank you, Jamie, for setting it up and for inviting me to be part of it. Look, as Jamie's indicated, I'm going to talk on two aspects today. So the first is obviously the restructuring redundancy process, and then the second we'll touch on what we see as the key changes that are going to come in over the next sort of 12 to 18 months under the government, the transition. As Jamie indicated, redundancies and restructurings, and I think the number of people that have registered in the webinar gives a really clear idea that this is still a really topical issue. I think even more so this year because of the economic impact of COVID. But the other thing that we see too is the processes are in all employment areas, and any business owner who is an employer will know this, is that it's really, really strictly governed by the process, how the process is followed, making sure that you get the process right, and that you conduct it in a fair and reasonable way. And unfortunately, what we are seeing this year is significant awards and compensation awards coming out of the Employment Relations Authority because there's been flaws in the process. Even if they're minor flaws, there's still the ability to award compensation to employees, or simply people just not understanding the processes. So for us, we're seeing a lot of restructuring and redundancies. Now, those two words are often used interchangeably. They're actually two different things. So redundancy is where there's a termination because the role is no longer required by the business or because of other reasons. And a restructure is often just a change in working circumstances, reducing hours to part-time, split shifts, those sorts of things. The processes for both are largely the same. And what I want to do, and I will just say that, look, we are obviously on borrowed time today, and it is a really detailed and involved area. So please don't take this as full, proper legal advice if you're about to embark on a restructuring or redundancy process. It's really important that you understand. I'll touch on the key things to know about, but it's really important that each step along the way you get some advice and support. Now, I know that businesses are under a lot of pressure and they don't want to pay money for legal advice or HR and employment support. The one thing I can say is that investing at the front end and getting the right support and guidance throughout the process is going to save you from potential consequences and significant penalties at the end. So when you're looking at a redundancy or restructuring, they're largely similar processes, and there's a couple of key things I want to talk about that a lot of people don't follow through or don't do, and they are the business case and the need for genuineness of restructuring and redundancy. Then we'll talk about the information, what information is required to be provided, because again, there's a lot of misunderstanding about how much information needs to be provided. I'll then touch on the process and redeployment, and then obviously I'll leave time for everyone to ask some questions. And as Jamie said, if we don't get to them all, I'll endeavour to answer them personally in the next few days. So when you're looking at a redundancy or restructuring, the courts have really sort of tightened up the processes. Now, the reason for that is, and we've all been guilty of it, I certainly have back in the early days of my career, you've got a poor performing staff member, you want to get rid of them. We all know how notoriously time intensive and difficult it is to performance someone out of a business. And so often the default was, well, let's restructure them out. So the courts have basically clicked onto that a few years back and really tightened up the processes around, well, what does a redundancy look like? One thing that they have said to the courts is that as long as you can establish as a business that there's a genuine reason for a redundancy or a restructuring, then it's not the court's job to look behind that or to, as they say, pierce the corporate veil. So effectively, as long as you can establish that it's a genuine need or requirement for the business to restructure, and then you do the process right, then you should be in a really good position to defend any personal grievances that may come out the end of it. Now, often people too associate restructuring and redundancy with financial. It's not the only reason. I'm involved in a couple of meetings this week for a client where effectively the business is going really well, but there's been a change in the online abilities of certain administrative duties and things like that. And so there's an administrative role that we're looking at, well, does the business actually need that person in that role anymore? And if not, is there something else that they can do in the business, or actually is that role superfluous to the needs of the business? So it doesn't just need to be about financial. It's about how's the business evolving, what are the needs of the business, and do we have too many roles to cover the duties and obligations that we need to. So when you first start out, what you need to start out by doing is setting up what's called a business case. Now, I've seen business cases that have been structural charts right through to 20, 30-page change consultation documents. It's about looking at, well, how much information do we need to provide in our business case? So your business case is about setting out for the employees that are potentially affected, what are the reasons for embarking on a restructuring process or looking at a potential restructuring, what is the information that you've used to rely on as business owners and directors to come to this decision? What are the various options so that the employees can fully and properly consult on those? And also, what information underlies that? Now, information's a really interesting one, and the courts have basically said information can extend to what is in board of directors' minds and heads, what they've discussed verbally at meetings, memos, internal emails, correspondence, all of those sorts of things form information as well as financial information. So you just need to be really mindful when you're putting things in email about a potential restructuring. If there's something else driving it, don't put that in writing. So if it is because you've got a rogue employee or a poor performing employee, don't put that in any communications between board members or directors or management, because that can potentially be disclosable. Financial information is also another really key area. A lot of businesses will say, well, I'm not prepared to provide financial information because it's commercially sensitive. If the driver for redundancy or restructuring process is financial, you need to be aware that you do need to provide financial information to the employee during the consultation process, which is sufficient to enable them and their advisors to consult. You cannot any longer hide behind that commercial sensitivity. Now, of course, we appreciate that they are commercially sensitive documents, and that information is not something you want getting out to the public or into your clients and customers' knowledge or hands. So there are ways in which you can protect the dissemination of that information, and it might be that you provide it to their advisors and it's not to be passed on other than viewed in their offices. Alternatively, it's viewed on site at the premises. There are restrictions and protections you can put in place around providing that information, but you do need to know that if financial driver is one of the key drivers for a redundancy or restructuring process, then you're obliged to provide that sort of information. So that's just something to bear in mind. So look, all of that information should effectively go into your consultation document. Now, your consultation document can be a letter or it can be a proposal, but what you should have in that is the basis of your business case, so the decision making behind why you're looking at a restructure, the reasons for it, the information that you've relied on, and what your proposals are. So it might be that you have a couple of different proposal structures, and I've done a number where they've had sort of a structural chart. This is what we look like now. This is proposal 1, and this is proposal 2. Then you consult with the employees on that. So they are entitled to sufficient time to consider the documents, consider the information, and ask for anything more. A lot of clients will say to me, well, what is a reasonable period of time? We'll always say, look, put your initial consultation document out and the relevant information supporting it, and give them about a week or so to get some advice and support. One of the key things, I have a lot of clients ring me and say, I want to do a restructuring. It's a Monday morning and I want them gone by Friday. Can we do that? The short answer is no, because a truncated process like that, you would need to have really, really clear justification for why it was rushed through. So it has to be, the consultation process has to be more than perfunctory. So it needs to be genuine, consultative, engaging. There needs to be sufficient time for the employees to get information and advice and support, and to have their representative there if they want. Now, the representative is entitled to talk at those consultation meetings. Some employees are not comfortable talking, and it's fully within the support person or the representative's abilities to be able to run those meetings and ask the questions. They may also then ask for further information, or they may put proposals to you for you to consider. One thing I would say is don't make a decision on the day. Come away, think about it, and then you need to think about how you address those sorts of things. In some processes, that will turn the process on its head. And actually, I've seen processes where we've embarked with a view that we're going to make a couple of roles redundant, and actually changed course and changed the structure, and everyone's kept their job just in slightly different form. So if you're going into a genuine process with an open mind, then often they do just sort of change and they can be fluid. If you are going in with a closed mind, so you know that you want a certain role or person gone, you need to be really, really mindful that you're not seen to be doing that. So you're not seen to have predetermined the outcome. It's all about, this is a proposal, we haven't made a decision, we want to consult with you about it, we want to get your feedback. And so once you get that feedback, you go back to them. There's also really clear sort of guidance on processes now. So if you make a decision, a preliminary decision, so at the end of all the consultation, you make a decision that you're going to proceed, my advice is strongly to put that in written form, explain the reasons for it, explain what might have come out of the restructuring consultation process, and that your preliminary decision is that you are going to proceed with the restructure. Give people another 24, 48 hours as best practice to make any further or final submissions before you confirm your final decision. That just ensures that everyone's been given a fair opportunity to be heard and to put their views forward. I'm just conscious of the time, but I do want to just touch on also redeployment. Now, redeployment is a positive obligation on an employer. I always advise clients to front foot that. So in your initial consultation letter, it's not predetermining the outcome, but it's addressing what is an obligation on you as an employer. And that is setting out your obligation as an employer to look at redeployment and the possibilities. There might be a lesser role that's being created that should be offered to a potential more senior person who might be losing their job. There might be opportunities for part-time in a different area, those sorts of things. So just make sure you're turning your mind to those and that you're able to talk to those and address those options during the consultation processes. But as I say, at the outset, sort of front foot that and sort of show the employer and their advocates that you've turned your mind to other opportunities in the business. Now, probably just before I will stop talking, because I can see the time ticking down and I tend to go on a little bit. One of the other things to bear in mind is that if you're doing a restructuring or a redundancy process where you've got someone on parental leave or about to go on parental leave, the obligations are slightly higher and there's a higher threshold to meet in terms of that consultation and redeployment. There is also what's called the 26-week preferential period. Now, what that means is if you make someone on parental leave redundant during their parental leave, there's a period of 26 weeks following that, whereby if the business has another role created, that it's offered as a matter of preference to the person who was made redundant during parental leave. So that's just a trap that a lot of people don't know about. But as I say, that's a really short whistle-stop tour through the process, but it's really crucial that you get it right and that you get advice and support during it. It's not uncommon for us lawyers to sit in on those restructuring meetings or to run them just to ensure that the information is being shared and that they're being done properly. So invest some time and money at the outset, because if you don't and you get it wrong, the time and money that you'll spend trying to fix it and clean it up retrospectively, it's just simply not worth it in this day and age. So just those are the key things really to bear in mind. And I'll hand back over to Jamie, because I probably have some questions to answer and I've been
come in leading up to the webinar during the week. But one little trick that I learned or read many years ago, when you feel like sending an email around to any person within your company or to your board or to your advisory board or to an employee, the first thing you should do is put your own name into the address panel, so that if you end up writing something you shouldn't and you push the send button, it comes back to you first. So you get a second chance to read it and digest it maybe later in the day. So if you feel a bit fired up and you want to send an email around, or it's something to do with restructuring, or it's sensitive and you're not quite sure and you want to spend some time drafting and composing it, and it is going to be an email, put your name in the send area first and nothing else, and then you can type whatever you like, because you get a second chance to decide whether it's the appropriate thing to send out. Now, one question that's regularly come up, Kirsten, over the week is financial disclosure. Now, many business owners are concerned about how much financial disclosure do they have to make to support a restructuring, because a semi-successful or a successful business owner might have a nice car sitting in the car park and it might be worth 50,000 or 100,000, and yet they're telling the staff we have to restructure and we're going to have 3 less people at the end of the period. That seems to put a lot of pressure on business owners. How do you handle that? Do you have to share your balance sheet? What information from a financial perspective do you have to share in support of a change?
Yeah, look, that's a really good question, Jamie. And I think the key, and we've seen it during the sort of lockdown and post-lockdown, where we're having to financially justify decision-making about reducing salaries. So during that time, the reduction to 80%, that's something that's going to be scrutinised a lot more. And the financial pressures from the top down. So if you've got shareholders that are still drawing 6-7-figure salaries or drawings, but you're making 10 people redundant because of the finances of the business, the courts are probably not going to look too favourably on that, because there are other options that you could be done. And Jamie, look, that's something we see a lot. Oh, so-and-so's driving around in his Mercedes. They're obviously doing okay. One thing I will say, and I do it a lot, and I'm very grateful to people like Jamie, who I've worked with a lot of clients on, and I work closely with a lot of other accountants. It's a really good process if you can get your accountant and your lawyer or your support person talking, because they can work out the financial information that's needed. Now, I wouldn't advise a client to just hand over 5 years worth of balance sheets. What I would prefer to do is to get something from the accountant on letterhead, which sets out where we've got to, why there's some financial risks. If financial is the reason for the restructuring, it might be another reason, and then you won't have to provide financial information. But if it's financial, work with your accountant to come together with a report that'll satisfy the lawyer on the other side. It'll look at the projections moving forward, and it'll look at the risks to the businesses without necessarily having to open the financial records for the past 5 years, which, to be quite frank, a lot of lawyers don't understand those anyway. So if you can work with your professionals to pull that information together in more of a report form, that's what's going to benefit the process, but also likely what you'll need to provide if you end up, God forbid, in court or in a battle with a personal grievance at the other end.
Right. Can you give me some indication, if you get these things wrong and it goes to court, what are some of the awards that have been made? Are they 3,000? Are they 5,000? Are they 20,000? What's an employer likely to be charged if they get something wrong? I know it's an open-ended question, but give us some guidance, please.
Yeah, look, back in sort of probably 18 months ago, we were in a much better position to say what we think were tariffs. And so for a flawed process that had been done wrong or that wasn't genuine, you could look at anything between 7 and 10 grand, possibly up to 3 months' wages and legal costs. Nowadays, particularly this year, the Employment Relations Authority particularly are giving out 3 months lost wages as a matter of course, whereas it used to be a discretion that they could exercise where there was evidence of trying to find work. It seems to be being handed out quite readily now, and it's not uncommon to see awards in excess of 12, 15 grand. So the awards are getting more. What I will say is the process we've got is that you go to mediation on a personal grievance, and then you have to go to the Employment Relations Authority. And if you're not satisfied with that decision, then you go to the employment court. Now, we've seen a lot, and I know one particular Christchurch business that's lost at the Employment Relations Authority 5 times and won 5 times on appeal at the employment court because the Employment Relations Authority's got it wrong. But that in itself comes with significant legal costs. You'd be spending over 50 grand in legal costs easy to get to the employment court. So it's a costly business. And if you win as an employer, you only get a tariff award of costs in the Employment Relations Authority, like the employee does. So it's 4,500 plus GST for the first day. I think it's 3,000 for every day thereafter. That's only a fraction of what you will have spent to get to a hearing. And then also you've got to rely on the fact that the employee's actually got the money to get anything back from it. But look, that also obviously creates a situation where employers just want to buy some certainty, so they will pay employees out. And it can be a dangerous sort of process, because if you've done the process right and you've provided all the information and you followed guidance, you've got to be a bit careful about setting the precedent of just settling with employees to make it go away, because employees notoriously talk. Look, significant financial penalties coming out and significant legal costs associated with it.
Right. Are the courts a little more lenient on small business owners? When I say small, they might have 1 or 2 or 3 employees, or 5 or 6, as compared with a bigger employer that might have 50 or 100. The small employer is more likely to get things wrong because they try and do it themselves. Are the courts a little more lenient?
Probably not lenient, but what the court will look at is what resources did they have the business have available to them in order to do it properly. Now, of course, that's not going to save you if you do it completely wrong, because there are plenty of resources out there. There is plenty of online resources, although you've got to be a wee bit careful about that. But look, yeah, they will look at, well, if you're a business of 100 and you're making a good profit, there is no excuse. You should have someone advising you and you should have paid to get it right. If you're a smaller business and you're struggling, yes, they will understand that and they will look at it on a resource basis. But if you get it wrong, you will still face those penalties. The problem, of course, that's going to arise is if you've got significant penalties against you, whether or not you can actually pay those. And that creates huge financial and emotional stress on business owners. So that's why I say invest at the outset, even if it's an hour or 2 of a lawyer's time, just to set you up, then you're going to put yourself in a much better position to protect yourself from those risks.
Okay. Now a question here about talking with employees without prejudice. If an employer sits down and talks with a single employee or a number of employees, and he or she says, right, first of all, this is without prejudice, I want to share something with you, does that carry any legal weight, or are they digging a hole for themselves?
Absolutely digging a hole. There's been some really clear case law, and interestingly enough, I had an experience recently where it was a partner of a law firm who had a without prejudice conversation with an employee, and it backfired big time. There is no such thing as a without prejudice conversation between an employer and an employee, and the courts have been really clear about that. Look, I will always talk to business owners, particularly the bigger businesses where they might be more senior level, and say, look, you've got 2 options. You can do it the legal way and the process-driven way and the time-consuming way, or you can do it the commercial way, which is going to result in a quicker exit, but it's going to cost you a whole lot more because there's significant risks associated with that. But there are 2 ways to do it. One's just going to cost you a whole lot more. But no, don't have without prejudice conversations with your employees, because there is no such thing. And once you've had that conversation, the horse is already bolted, so you then can't backtrack and put on foot a genuine restructuring process, because the employee is going to say to their lawyer, well, he's already told me he wants me to go and he offered me some money, but I turned it down. There's just no way to claw back from that. So stay well away from those without prejudice conversations.
So it seems to me that ignorance is no defence.
Exactly.
And best intentions don't work either.
No.
You just have to get these things right. And if it means engaging with someone like you, just get on and pay the bill and hope you get everything right. Now, what about an employee? Another question that's come in. What about an employee who's deliberately obstructive because they sense that they may be getting restructured out of a position, and they don't engage and they just sit back? They sit back and they are reluctant or deliberately obstructive. How do you handle that situation?
Yeah, look, and again, that's something where it's a frightening thing to do, and it's a frightening thing to proceed and carry on and make decisions without the employee engaging. So it's a balancing act between giving an employee a reasonable period of time to engage, but also to carry on with the process once you've satisfied yourself you've done that. So that's why, if you've got an employee who's effectively getting the information and just delaying for no good reason, then there are ways and means that you can continue that process. And it's about putting that employee on notice that, look, you've had 3 weeks now. We've made every endeavour to try and meet with you. We're setting a meeting. This is the time and the date. You and your support person or advocate are more than welcome to attend, but you need to be aware that if you don't engage, we can proceed without your engagement. So that's not something within 2 days of issuing the consultation process, but that's where you as an employer can show that you have made every endeavour or genuine endeavours to engage with the employee, to set up times that are convenient to them and to provide them with information, but they're simply just going, the longer I delay it, the longer I'll keep my job. Then as long as you can satisfy that you've taken those steps, there are still ways in which you can proceed with that process and make decisions without the employee's involvement. Bear in mind, just be really careful. People say, oh, we'll just do it by email. I always advise against that. I think face-to-face meetings and consultation meetings are really important. And I've had one recently where there was an email consultation, the document was sent out. The employee says they never got it, and the employer proceeded on the basis that they did, but didn't engage and made them terminated their employment. And so now we're sort of trying to mop up a personal grievance about, well, hang on a minute, I didn't even know that the process was on foot because I never got the email. So that's why it's really important that you're just not relying on email communication, but you're talking to your employees, introducing the concept and discussing with them potential dates for meetings and things.
Okay. So restructuring, is the word restructuring just smoke and mirrors and a bit of a disguise for an employer who has a difficult employee or simply has an employee who's underperforming? They want to move that employee on and free up their future, as the euphemism goes. What's the process? You don't want to go through the facade of a restructure. You have an employee you believe is underperforming. Talk through the process of how a good employer should handle that situation.
Yeah, look, performance is one, and I still see a lot of clients coming to me with a poor performing employee, and they want to find a way to restructure them out because they don't have the time or the resources to do a formal performance improvement plan. Now, if you are wanting to go down the performance route, and that's because potentially you can see some potential in the employee, or you just want to do that rather than a restructure, then that again, much like anything in employment law, is a really involved process. So the courts say an 8 to 12 week formal performance improvement plan is what's reasonable. That requires an initial consultation meeting with them to say, look, we're concerned about your performance. These are the areas we're really concerned about. This is a draft performance improvement plan. Have a look at it, come to the meeting, bring someone with you, and then we'll finalise the performance improvement plan. And what we're going to do is we've set some really clear KPIs, which are key performance indicators for you. We're going to set some really clear marking and achievement scales, and we're going to meet with you every week, and we're going to mark you against those. You can mark yourself, and we're just going to monitor you over the next sort of 8 to 12 weeks. That is the proper way to do a performance improvement plan and or a performance exit. But as I say, a lot of business owners glaze over, quite frankly, when I tell them that that's the proper way to do it. And so it's not uncommon, and I can say this because I know any other employment lawyer out there would be able to say the same. It's not uncommon to find a way to potentially create a restructuring process or a system whereby there's an easier exit. But as I say, you've got to just be really careful because you cannot merge the two processes. So you can't talk to someone in a restructuring process about their poor performance or that being the reason why they've been identified. But yeah, both very involved processes, both can go horribly wrong. But you just need to be really clear at the outset about what processes you want to commit to.
Right. Now, just a couple of points, housekeeping points for those who have joined us halfway through the webinar. It is being recorded, so if you've registered for the webinar and you have to go off somewhere more exciting than Kirsten, good luck. It is being recorded, and after the webinar, probably later on this afternoon, when everything's been finalised, you will receive a link to be able to watch this whole webinar at your leisure at any stage in the future. So don't panic if you have to leave. You won't miss anything, but please don't leave if you can. Hang in there. Now, a question just come in from email here is what are the responsibilities when a company or a business is going to be sold? Now, in a way, that's a total restructure. A new owner comes in. It's probably just to one side of what we're talking about, but maybe just a quick overview, the responsibilities of the vendor selling the business to current employees.
Yeah, sure. So, look, that's an interesting one. And a lot of people, when you're dealing with the business sale, it's being dealt with by the commercial team in a law firm, or by, commercial experts or property experts who might not understand or be skilled on the employment side of things. And so it's really important, again, that you have those professionals talking. I've been involved from an employment perspective with another firm recently, a firm up in Marlborough, and they were dealing with the sale of the business. Now, the key there is there'll be clauses in most employment contracts that says an employer who is selling a business will use best endeavours to get the new purchaser to take on employees or to make an offer of employment. They can't force them to, but often it will be a clause that's contained in the agreement for sale and purchase of the business, so that you'll have an employment clause, and it's always good to have an employment lawyer look over that, but it'll be about, the purchaser will offer in the first instance employment on the same or very similar terms to the current terms to all current employees. So that's a way of doing it. But as I say, you can't, as a business owner selling a business, you can't force the new owner to take that on. One of the things that keeps coming up for us when you're dealing with that is, well, when do I tell employees? Now, I recently had a client who was very distressed because she had been told that she had to tell the employees at the very outset before there was even an unconditional agreement on foot. Now, that creates a whole lot of anxiety and uncertainty for employees. And yes, you've got an obligation to share that information, but you wouldn't share it until you knew that the business sale was going to go through. Because if it doesn't go through, then you've unsettled all of your staff, you've got them talking, you've got them starting to look. So generally what we do is we work with business owners, you get your agreement to purchase the business on foot, you make sure that you've satisfied your obligations to try and use your best endeavours to get the employees offered employment. And then once you've got an unconditional sale, you'd always factor in enough time so that you can then message to staff. They then get the option to transfer, and there's an election notice that gets drafted up and signed. And then they just transfer employment on settlement date to the new employers. So again, it's something that we do time and time again, and it's just making sure that you've got the right professionals talking to each other so that you've ticked all your obligations off. But also it's about the messaging and the timing of that messaging so that you don't end up having it backfire if the sale falls through and you've got a whole lot of staff that are starting to look elsewhere because they think you're going to sell the business out from under them.
Okay. Here's one more question, and then we'll go on to the next subject that you want to talk about today, Kirsten. How do you deal with an ongoing performance problem or restructure with someone suffering from mental ill health? Are there any extra considerations you need to make?
Yes, look, absolutely. That's something that we see time and time again. And I'd be careful I choose my words here. As someone who primarily these days works for business owners, it's not uncommon for an employee to throw stress or something like that into the mix when actually they're not suffering from stress-related anxiety disorder or a mental health issue. But you also have to be really mindful of that. And so it's about engaging with that employee and not being afraid to have those conversations. And it might be that if they've got an advocate or a representative, just getting them to satisfy you that they're well enough to engage in the process. If necessary, you can get a doctor's report. It's not uncommon for employees to get signed off by doctors for a couple of weeks when this process happens. I've seen doctors challenged in court on their medical certificate signing employees off on stress leave, is what they call it, which medically there's actually probably not such a thing. And when you start cross-examining the doctors about the tests that we're undertaking and how did they come to that medical opinion, it very quickly starts to unravel. So it's a really delicate balancing act between an employee who's just gone off to the doctor and said, I'm really stressed at work, can you sign me off? And they get signed off, as opposed to someone who is really suffering from significant mental health issues. And likely they probably have been on your radar in any event. So again, it's about making sure that you've got some professional support and advice. Might be that you take some advice from a medical professional or from their treating professional if they've got a psychiatrist or a psychologist involved. But the starting point is to have a conversation with the employee about how you manage that process so that it causes the least possible impact on their difficulties and or deal with that through their professional support network and advisors and things like that to make sure that you are cognizant of what they're going through, but also able to manage the process still in a proper and professional way that's not going to impact on them even further.
Right, thank you, Kirsten. Now, I said we go to the next subject, but there's just one more question that's come in. I think it's worth sharing. Again, it's about disclosure of financials. With regard to showing financials in a financial restructure, do you need to show financials right at the outset or only when requested? What's your advice there?
Yeah, look, your business case and your consultation information is really crucial, and that should contain all of the information necessary to enable an employee to properly and fully consult. So if we're looking at it black letter law and you're making a decision to restructure or look at redundancies because of financial information, an employee can't properly and fully consult with an absence of financial information. So what I often do, and I look, it's not surprising and it's not uncommon that there's a lot of resistance to providing that information, even when it's justified, that the restructuring is justified, still that fear of, I don't want my employees seeing all of that. So what we often do is put enough information in there. So it might be some figures, it might be some projections, and it might be some percentages about what we're at, and then offering more information if they want it. But you wouldn't get far in a consultation process if you provided no financial information, but that was the reason for you embarking on that process. So again, it's about talking to your professionals and having the right network of accountants and lawyers talking to each other to be able to put enough in there to help them embark on the process, but also being open-minded to the fact that they might want more information as they go through that process.
Right, well, thank you, Kirsten. Okay, on to your next subject, all the things that are changing. I think it's on the 1st of April next year.
Yeah, there's a few then.
I'll let you take over again.
Thanks, Jamie. Look, the one thing I will say on this is there's a couple of key areas that I want to touch on. A lot of this information is still coming out, so we don't have all the answers yet, but what I wanted to do today really was just highlight some of the key changes that are coming in over the next 12 to 18 months. There are some coming in April, there's some coming in June, and then there'll be some more changes and development of policy as we go through. But it was really just an opportunity, A, for you guys to ask some questions, but also just to highlight some of the key things coming in. So one of the big ones coming in, which a lot of people actually don't know about, I've been talking to a few professionals recently and they're like, what is that? So what it is the triangular working arrangement. So it's a bill that's being passed to amend the way in which triangular working arrangements work. Now, what a triangular working arrangement is, and I've got a perfect example. I act for a national company that is a recruitment hospitality company. They've got a number of candidates who are employees. So they're employed on a variety of casual, permanent, part-time or full-time employments agreements. They're then placed by that company in various different entities around New Zealand. So hospitality venues, catering venues, cleaning services, hospitals, restaurants, bars and cafes. Now, you place an employee who's on your books as a candidate, but they're an employee in a third-party premises, and effectively that's kind of where you step back as the employer, because you're not there day to day. You don't make the decisions in let's say it's a cafe, you don't make the day-to-day decisions, you don't see what's going on, you can't control the behavior or the conduct that's being that's taking place in that business, and all the way that the management or the owner of the cafe is treating your employee who's placed with them for a short-term placement. Currently, as it stands, it's very difficult to take a grievance against that person, that third party who's effectively doing, let's say they're bullying or they're allowing bullying behaviour to take place, or they're treating this person poorly, or they're not allowing them to take breaks. There's very little recourse that your employee who you've placed in that cafe has against that third party. What they have is the ability to take a grievance against you as an employer, but you haven't actually been the one that's been carrying on in that manner or that's given rise to the personal grievance. So what we are going to see next year, and it's coming in June next year, is a change to that. So there will be the ability from the middle of next year for the employee, your employee who's placed with that third party, to take a personal grievance against both their employer, legal employer, and the third party, which is the controlling third party day to day. So there will be the ability to raise the grievance against both of them. Both parties will have to engage in the mediation, and if not, then it will go to the authority and it will be directed to the third party to engage. And then if it ends up before the Employment Relations Authority or the court, they can award against both parties, so the employer on the books and the third party, and it might be in different shares. It might be a situation too to where they don't make an award against the employer because they've done everything right, and it's just the third party who's conducted themselves in an appalling manner, which has given rise to the grievance. So one of the things, and Jamie and I have spoken about it, and it may actually be that we run a separate webinar on this next year, because one of the things you'll have to prepare yourself for if you're in that situation is to make sure that you're doing all you can as the employer to ensure that you're placing candidates or employees in an environment which is proper, it's safe, they've got proper policies and procedures. And if you don't know what happens day to day, and you don't know what their policies are around bullying or poor performance or disciplinary issues, or look, we have a situation recently where it was a no visible tattoos policy. They got placed, they got walked off the next day, and at the moment they can't take a grievance against that person. So it's a really interesting change, but I think it's a good change. It's right, because as the employer on the books, who has very little control over what's happening day to day in the third party premises, it just seems a little bit fake that that's where the liability lies at the moment. So that's an area that's evolving and changing, and those changes will come in next year. And as I say, it's going to have some huge impact on some big industries like hospitality, cleaning services, and things like that. So look, if there's interest in that, as I say, Jamie and I will look at putting something out with a bit more detail, perhaps early in the new year, in terms of what you need to do to get ready for that, and prepare. The other thing, and probably the one that most people have heard about, it's certainly one that's been in the news the most, is the change to sick leave entitlement. There was a suggestion that was going to be rushed through by the end of the year. That's not going to happen. So what the government has said is, look, we'll introduce that. It'll happen by the end of next year. We're going to give people time to make sure that they've got their records and their payroll and everything, and they prepare themselves for it. So what there is going to be is an increase in sick leave entitlement. It will still be on the same basis, so you'll have to have done 6 months continuous employment before your entitlement kicks in. But after that 6 months, once the changes come into force, employees will be entitled to 10 days sick leave as opposed to the 5 now. What they won't be entitled to is an increase in what they call the carryover. So that's not changing. So the Holidays Act provides that once you've got to your entitlement of sick leave, you can carry over in any 12-month period up to 15 sick leave days to a maximum of 20. So that's not changing. So the maximum carryover and accrued sick leave is not increasing. It's just the number of days that employees can take within the 12-month entitlement period. And look, there's mixed responses to that. A lot of people have said, oh, it's an extra 5 days, so what? For small businesses where they have key members of their team, and a day out of the office or off site or out of the workshop can have a significant impact on productivity and other team members. So another 5 days of that could potentially cause problems. So the next sort of 12 months is about getting your ducks in a row, thinking about all of us have had employees on our books who don't turn up on a Monday quite regularly. That can extend. So it's about thinking now, well, do I have any potential issues there? Do I have any employees that I'm concerned about? And how do we put in place some measures to ensure that the increase in sick leave has the least impact on my business as I can? Bearing in mind that, when there are genuine reasons for sick leave, and look, we've all seen the measures and the safety measures that we have to take nowadays. There are genuine reasons for sick leave, and a lot of employees don't take the mickey out of it. But look, it's interesting, and I generally, the feeling I've got from my clients are that they're not happy about it. But the reality is it's coming in, and we need to prepare for it. So that's something just to bear in mind. It's not retrospective, it's moving forward, so you don't have to backdate or anything like that. It will be implemented from the date that it's implemented next year. Probably two more things that I just really wanted to touch on. And again, one of them is more specific to industries, but there may be some of you out there who are in union industries. So one of the things that they are talking about, and probably going to change, because The focus of the government is about protecting vulnerable workers and ensuring transparency and equality. And they've very clearly set that message out. So there's going to be access to information to ensure that there's equality of pay. And the clearest example is a male and a female in the same role within a company. Are they being paid the same if they're at the same skill level and experience level? And if not, why not? So that information is going to become more readily available. But the collective bargaining. So the big union industries, transport, nursing, things like that. One of the things that they are looking at doing is changing it from, because currently how we do collective bargaining is it's done with the union and the union members, so the employees who are union members and the employer. Now that bargaining process takes place and then that has a flow-on effect for other employees, and there's effectively a pool of money that's allocated out after the bargaining takes place. What they're now looking at doing is making it industry-wide bargaining. So it's not potentially not individual employer union bargaining, but it's industry-wide. And that the decision-making after that and the changes in pay rates and other benefits that are implemented as a result of industry-wide bargaining will then have to apply to all other employees. So again, that could have massive consequences. And I see some real issues with industry-wide bargaining, but also the impact that can then have on all of the other employees and your business if you then have to apply those changes across the board to all employees. So as I say, that's not been implemented yet. There's no really clear deadline or date for when that's happening, but it's very much front and centre of the proposals for change. And I suspect if that's going to come in, the time that it's going to come in is in the next year or two with this government. So again, as we have more information about that, we'll certainly be able to provide it through this platform and possibly do another webinar to update you. And then probably the final thing that I just wanted to touch on, and again, it's not set in stone yet, but this is definitely something that will come in. And the reason I say that is because there's been a real shift. So what this one is about the protection of dependent contractors. So you've got employees and you've got independent contractors, and often they blur. And there was a case just a few months ago that came out of the employment court where a worker was on an independent contract. The owner of the business treated them, they thought, as an independent contractor and thought they could present the contract and say, look, they're a contractor, they're not an employee, they can't bring a grievance. But the courts basically said, well, actually, if we put the contract to one side and look about what's happening on the ground, they're actually an employee. They can't work anywhere else. They don't have the ability to build up their own business. They're working on your business. They've got to be there for set hours, which are employee hours, and they do what you tell them to do. So unlike commercial law where the contract governs all, so if you're having a dispute, you go to the contract. What does it say? What does the lease say? Employment law is very much about substance over form. So you might have an employment contract or you might have an independent contractors agreement, but if that's not what's happening on the ground, the courts can effectively put that contract to one side. So there's been some real changes in the way in which courts have approached the independent contractor relationship over the last 12 months. And one of the proposals that the government's indicated that they will look at bringing in next year, and I suspect it will be next year, is the protection for those dependent contractors. Now, those are contractors who are contractors on the books, but work only for one business and effectively are under the ultimate control of that business owner. So they'll look at protections like entitlements, minimum rates and things like that to protect them. One thing I will say is if you're in a situation where that's what you've got and that contractor doesn't work for anyone else and doesn't build their own business in their own time or on other days, you're possibly blurring the lines and you may well find that you've actually got an employee on your hands. So again, before you bring contractors on board, make sure that you're aware of what that looks like and what that has to be. So that's, you know, the key distinction is that the primary focus for a contractor is that they are building their own enterprise. And as part of that, they might do some work for you and they might do some work for someone else and they might do some work for someone else, and that's okay. If they're only doing work for you and they're really at your direction and control, chances are you might find if it all turns sour and they challenge it, that the courts may determine that you've actually got an employee on your hands, and then you open up a wage arrears claim and entitlements claim. So something that has been changing and evolving and is going to keep evolving and changing, very much focused on protecting those dependent and vulnerable contractors. And then probably just the final thing I should say is there's going to be a big increase to minimum wage. So that's going up to $20 an hour as of the 1st of April. What happens after that, I don't know. It'll only increase every year, but we may well see it going up quite a bit. And so you just need to be mindful of that and make sure that you've got everyone on the minimum wage. One of the things I see a lot, particularly in the agri industry, for instance, is employers will say to me, oh, well, it's all swings and roundabouts. So they worked 120 hours in one cycle and only 10 in the other, so we'll just balance it out. That's not okay. And if that was challenged, you'd face some real issues with that. So it's the pay periods. So for every hour worked, say if it's a fortnightly pay period, for every hour worked over that pay period, you've got to make sure that the employee is earning minimum or above minimum wage for each hour. So again, another big impact on small to medium-sized businesses particularly, and I know that there's a lot of business owners out there feeling pretty beaten down after the year we've had, and a little bit despondent about what's coming in. But the reality is these changes are coming and we've just got to prepare for them. And so all I can say is just make sure that you're getting as much information as you can. If you've got HR advisors or lawyers, make sure you're talking to them. And again, Jamie's going to put my details on the webinar and things. So if you need to get in touch or you've got some problems that you want to work through, then feel free to reach out.
Thank you, Kirsten. Talking about disgruntled employers, we did have one client come to us when they heard about the increase of sick leave going up another 5 days. They said, I want you to redo my budgets with the new minimum wage and also add in 53 weeks of pay into my budget, because that's effectively what I've got to deal with if sick leave goes from 5 to 10 days. It's effectively another week. Please make my budgets 53 weeks long, so I've got a real handle on what my bottom line will be. Now, just a brief question here. Just explain the difference between minimum wage and the living wage. We think we know, but maybe a clear definition from you will help us understand it better.
Yeah, so look, they're based on different things. So the living wage looks at expenses, not just work, and the minimum wage looks at hours worked and the amount that you must earn when you're working. And also bear in mind that there are age distinctions. So for 15-year-olds and 16-year-olds, the first 6 months they can be on a lesser wage, but then after 6 months continuous employment, they have to go up to the minimum wage for employment worked. And the living wage looks at a bigger cross-section of expenses and things like that. Now, we all know, and look, I look at what I first started earning when I started out my career, and I can't believe I survived on that. But, the minimum wage is just about your hours work. The living wage is much more about, well, what does it actually cost you to live? And so that's how they're sort of worked out. Do I think that they're going to be aligned in time? Yeah, quite possibly. And if any government's going to do it, it'll be this one.
Right. Now, another question I'll read off the screen here. How many hours per day does a part-timer need to get the 10 days sick leave?
So look, it's going to be just as it is now. It's on a pro rata basis. So with annual leave, sick leave, and all of that sort of thing, everything's prorated. So if you have a good payroll system, they'll work it out. So after 6 months continuous service, regardless of your hours, so let's say, for instance, someone works 10 hours a week, then they'd be entitled to that on a pro rata basis. So the 10 days at the whatever hours they average work. So that will require you to work out with your payroll system and or your advisors about what does it look like on a pro rata basis, much like you do with annual leave. So if someone works 10 hours a week, they don't get 20 days annual leave of 40 hours. So it's worked out on that pro rata basis. So it's the same principles apply. It's just an increase in entitlement.
Right. So when it goes to 10 days sick leave, do employment agreements have to be rewritten, or does the law override them all and they don't have to be touched?
Yeah, look, the law overrides them all. So most employment agreements will provide for, well, they might be specific to say that you're entitled to 5 days annual leave in accordance with the Holidays Act. Look, belts and braces, if you want to change it, you can, but it's just more paperwork. The reality is, once the legislative change comes in, you're bound by it. So you can't contract out of those obligations. There are certain things your contract can provide for in variations, but what you can't contract out of is your obligations of minimum wage entitlement, annual leave entitlement, sick leave entitlement, bereavement leave, and domestic violence leave entitlement. So those are obligations under the Holidays Act that you must abide by, or you can face penalties as well as grievances about those. So regardless of whether you alter your employment agreements or not, once it's in force, you have to abide by it. And then, as I say, with employment law, it's substance over form. So if you, moving forward and 12 months down the track, you don't have changes in your employment agreement, they still talk about 5 days, as long as you're giving your employees 10 days, then you're compliant. So it won't matter that your employment agreement might be an older one that refers to 5 days.
Right, thanks, Kirsten. Well, this will be the last question because we're just coming up to 1 hour now. And we have said already that all the questions that have been sent in, either via email or on the screen here, they will be answered by Kirsten later on if we can't get through them today, which we obviously can't. So there's one last question here. Can I use other benefits like accommodation or a vehicle to make up to the minimum wage?
No, absolutely not. We see that a lot, and I see it a lot with my agri clients. The Act says quite clearly that employees have to be paid money for hours worked. And again, there's a whole blurry area. Well, what about volunteers or interns, which I won't go into because we don't have time. But no, if you've got an employee that's undertaking employment duties and work, they must be paid in wages and it must meet the minimum wage requirements. On top of that, of course, you can make deductions so you can charge them rent and that can be deducted. And look, it might be more of a paper exercise than anything, but you need to be able to establish it for the hours they've worked. They've been paid from 1st of April next year, $20 per hour for every hour worked. And then your service tenancy clauses in your employment agreement will provide for, and they'll be charged $150 a week for accommodation. But you cannot sub in a vehicle allowance or accommodation or food or something like that in lieu of minimum wage entitlements.
All right. Well, thank you, Kirsten. You have been wonderful today, clearing up a lot of general questions. I know this subject concerns and worries a lot of employers. Employers are generally hardworking, committed.
Yeah.
They put an awful lot on the line to fund their businesses, and they go about their business with good faith and good intentions. And most of the employers, and certainly most of our clients, they love their employees. But they just get caught up sometimes in the difficulties around the law with employment. So, what I've learned today is good intentions and ignorance of the law is absolutely no defence. So I know it sounds like a little bit of a fee fest for lawyers and maybe accountants along the way, but boy, if you don't get it right, your reputation as a good employer can suffer. A disgruntled employee can spread bad words about your business, and we don't want that to happen. We know how things on social media can get out of hand. So as a good employer, invest the money, get great advice. I can't recommend Kirsten high enough. We will be sending out a recording of this webinar later on today, and Kirsten will see all the questions that have been unanswered and will take personal responsibility, won't you, Kirsten, to answer one of those over the next few days. So that's a big ask on Kirsten, but that was the commitment that Kirsten made to the Brainstorm Room and its members and the people who have joined the webinar today. So look, thank you very much for joining in. You will get a recording. So thank you, Kirsten. Any last words for employers?
No, look, I mean, I know it's a really tough time. It's been a really tough year, and it's a hard jurisdiction to work in because I'm constantly delivering bad news and that to employers, and I know how tough you're doing it and how genuinely people want to get it right. So look, I understand it's a really tough gig, but that's why if you've got the right support around you, we can take some of that stress away from you, hopefully.
All right. Thank you very much, Kirsten, and
Thanks,
thank the
Amy.
audience for joining us today. Thank you.